And a section in that law, Section 230, reads this in part: no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Okay, so in simpler terms, you can't sue a social media company for what a user posts or uploads on a social media platform. But depending on how the justices rule this week, all that could be changing. Joining us now to share his insight is Mike Davis, president of the Internet Accountability Project. Mike, welcome back to the show. All right, the Supreme Court has never heard a case on Section 230, and now this week they're going to hear two cases on Section 230. Many people are saying if they rule to change this section in any way, it could actually change the Internet as we know it.
These big tech platforms argued the same thing. They said that if Congress changed Section 230 to try to go after child pornography, it was going to break the Internet. That never came to fruition. That's just a scare tactic by Google and Facebook. What the court needs to decide here in this Gonzalez versus Google case is when these big tech platforms use their algorithms to amplify content. They use their algorithms to micro-target users, and that leads to bad acts like terrorism. Can Google be liable under that, or does Section 230 immunize their bad behavior here? Google says that they're immune under Section 230. The family of this 23-year-old American girl who was killed in Paris back in 2015 by an ISIS attack says no. Google is liable. They were the publisher here. They were the ones who used their algorithms to target these terrorists.
Okay, so I want to talk about the algorithm a little more, but I want to play something that Senator Lyndsay Graham said last week in a Judiciary Committee hearing on Section 230, because this has been an ongoing issue. So listen to this.
Is it pretty clear that Section 230 prevents individual lawsuits against these social media companies? Everybody's nodding their head. You can't sue them. There's no agency with the power to change their behavior.
Okay, so ultimately, right now, both these lawsuits, so one, as you mentioned, against Google, who owns YouTube, and another one against Twitter. So they're arguing that these tech companies may not be liable for what users post, but back to what you said, the algorithm that promotes what people are seeing. So, I mean, some people are saying that the Supreme Court doesn't quite understand this new technology, and technology is evolving. So how do you make rules against something that is constantly evolving and growing? And are these the right people to be understanding how to put something in place that will actually have staying power?
Here's the problem with Section 230. It was passed back in 1996 to protect Internet infants like CompuServe, Prodigy, America Online, so they didn't get sued off the map by publishers based upon what people posted on these online community bulletin boards. Fast forward more than 25 years, and through this bad combination of Section 230 immunity and antitrust amnesty, these Internet infants have transformed into Google, Amazon, Facebook, and Apple, trillion-dollar big tech monopolists that use their market power to crush competition, shutter small businesses, and cancel conservatives and others with whom they disagree. Congress needs to fix this law. Section 230 is no longer needed for trillion-dollar companies. Maybe we have Section 230 for the smaller companies, but once you get a market cap of maybe $600 billion or whatever the number is, why is the federal government subsidizing these trillion-dollar companies so they can use their algorithms to harm kids, revenge porn, terrorist beheading videos? It's just filth out there, and why are we protecting them?
I mean, it's a good question. I mean, some people have raised as well, are there unforeseen issues of changing 230? Obviously, the big tech companies don't want it to happen because they're protected. But what are some of the ramifications that maybe you have concerns about that the Supreme Court needs to think about and make sure the law protects those unforeseen issues of changing 230?
Well, maybe, like I said, maybe you make 230 protections for the smaller companies, but once you become a big company like Google, Amazon, Facebook, Apple, you take off the training wheels. It's amazing that these big tech platforms can hunt down, find, censor, silence, cancel conservatives and others with with whom they disagree pretty easily, but they can't go after revenge porn, terrorist beheading videos, these ISIS videos. Of course they can. They're making a lot of money off of their algorithms, and that's why they're not taking down this horrific content.
And it is a good point, because the algorithm, and he this is a Google case, this YouTube case, the family's trying to say that people watching these terrorist videos, they were targeting these people to continue to see violent activity, which is drawing them to make bad decisions. So it is an interesting argument. We'll keep watching how the Supreme Court rules on this big cases this week. Mike Davis, appreciate your insight on those.